Hi, my name's Sam Corse. I'm a legal executive here at Whitehead Monkton Solicitors, working in the Contentious Probate team, which is headed up by my colleague Emma Salmon, who also joins me today. She's a solicitor in the team. We've just got a case study that we're going to run through today, just about the pitfalls, essentially, in executors administering an estate and also acting as trustee off the back of anything contained within the will. Emma's just going to read out the facts of the case study, and then she's going to ask some questions that I'll answer. So I'll just hand over to her.
Thanks, Sam. So the situation that we have is a lady called Paula who died aged 39 years old, leaving two children, the first one being Lewis, who's aged 12, and Jodie, who's aged 10. Paula made a will which appointed her friend Julie to be her executor and trustee. She appointed her mother, Irene, to be the guardian for Lewis and Jodie, and left her entire estate to Lewis and Jodie for when they reached the age of 21. Their father had predeceased Paula. Paula had a property with no mortgage and additional money in bank accounts. What is required to be done with the estate?
Firstly, obviously the estate just needs to be administered from a standard estate point of view. The key thing here being that obviously Lewis and Jodie, they're minors and they can't actually outright take their entitlement from the estate, obviously, until they attain the age of 21. So that money just needs to be looked after and protected for them until that age. Julie here under the will was appointed as the trustee of that money, in addition to being the executor when dealing with the estate. So it's important that she obviously protects that money. She needs to be placing that in a trust account, considering investment and capital growth of it. And also there is legislation that provides that some monies can be applied to Lewis and Jodie before 21, and these just need to be considered in working alongside Paula as it's sort of as the trust goes on. So that's sort of like the initial things that need to be considered here.
Okay, that's helpful. I've just got a few questions more so about whether something that Julie has been doing is correct and so forth. So for instance, Julie paid herself a salary for acting as an executor and also paid money to her own children from Paula's estate, as she believed Paula would have wanted them to receive something. Was she right to do that?
No, that's firstly with the salary for acting as an executor. It depends what the will says. First off, the will can authorise herself to be paid a salary. It's quite rare that that's the case where you've just got a lay person acting as executor. Usually, executors are only entitled to out-of-pocket expenses. Certainly, just taking a salary is wrong, and Julie could be in breach of trust here for doing so as an executor and liable to pay that money back. Certainly from the point of view of what she thinks Paula would have wanted in terms of her children benefiting, again, that's a strict no. She needs to follow the terms of the will. That money's for Lewis and Jodie. So again, if she's ultimately liable to pay that money back to the trust. That's certainly something she can't do.
Okay, that's helpful. Thank you, Sam. So another situation here is we've got Lewis and Jodie who left Paula's property and moved in with Irene. Julie allowed then for her own daughter to live at the property free of any rent for 3 years whilst at university. Julie would use money for her benefit from the trust and loan money from the trust to her own friends. She only kept the trust money in a personal account and failed to invest the money, which was held for Lewis and Jodie. So there's a few concerns here that seem to be raised. What would you say the implications are of Julie doing this?
It's almost the opposite to what I said at the start of what should be done. Firstly, with the property, it's quite normal, obviously. Lewis and Jodie aren't going to live there, but what she needs to do with that property is weigh up whether she's going to keep that and rent it out or sell it and invest after taking some investment advice. What she certainly can't do is with her own daughter just move her in. That's the daughter isn't a beneficiary under the will. She's got no right to live there, and what she's potentially risking here, well, she is by not charging any rent. There's no benefit to the trust. There's no income being produced, which could then be reinvested for Lewis and Jodie, for them to have in the future. There's also the risk, it mentions university, there's a risk here of damage to property. You don't know what the daughter's doing at the property and whether it's being maintained, and Judy is certainly placing herself at risk of breach there. Could be liable for any damage to the property, personally liable, certainly there, and she certainly is breaching her duties. With the money for her benefit, it sort of comes back to the salary position. A trustee can't benefit from their position, and they can't make a profit from their position. It's a breach of her fiduciary duty, that, and so she would be account to repay that to the trust. She's also, again, potentially at risk here of the money she's loaning to friends. I doubt there's any security on those loans, and whether there's any interest being charged, it's really dangerous territory that she's going into. And then even more dangerous, just keeping the money in a personal account and not protecting it in a trust account. It leaves it open to being mixed in with her own personal funds, which she can't do, and she needs to really place that in a trust account and take solid investment advice on all of those issues, really. So she's really potentially putting herself at risk of breach here. Just on the point of who could bring that, Irene certainly as a guardian for Lewis and Jody could potentially ask questions of her, potentially sort of bring questions, and if she's not administering the trust correctly, or she's impacting the proper administration